This is a really quick video to talk about special reasons in drink driving cases. What are special reasons and how exactly do you raise them? Now, first of all, a special reason is not a defence because it involves pleading guilty. There's often some confusion about when you can raise a special reason and what actually amounts to a special reason. So it involves entering a guilty plea to the allegation of drink driving, but it's the idea that your culpability, that's your blameworthiness, is so greatly reduced in this particular case because of a reason that the court ought not to disqualify you or to substantially reduce the driving disqualification. But it does involve pleading guilty. Now, for that reason, a special reason in my view should be a plan B. You can always challenge the allegation to start with, check the evidence and try and avoid a conviction. If you can, happy days, because then there's no driving disqualification, there's no penalty. If you can't, you can always fall back on special reasons as a plan B, if you like, keep it in the back pocket. You can argue special reasons at a later date. Now, special reasons isn't the same thing as mitigation. Anyone can put forward and present mitigation in circumstances where they are convicted of a criminal offence, including drink driving. And mitigation is the idea that if you lose your licence, you're going to lose your job. It's going to have an impact on family. You can't take the kids to school, you can't drive to and from work. And that's all general mitigation, and the court will hear your mitigation, and you can sometimes persuade them to reduce driving disqualifications, try and keep them to a minimum, rather than send you to prison, give you a suspended prison sentence, rather than give you community service, to impose a small financial penalty instead. And that can work well, but that's not the same thing as special reasons. There are really only 4 commonly argued special reasons for drink driving cases. The burden falls on the defendant to prove on a balance of probabilities that their particular special reason argument applies. I'll give you some examples in a moment of common special reasons, but remember, you have to prove on a balance of probabilities, that's a civil standard of proof, more likely than not, that the special reason argument applies in your case, and you're usually always going to need some kind of evidence as well to back up your argument. So firstly, the most common special reason argument that you see being raised is spiked drinks. And that doesn't mean to say that somebody's maliciously spiked your drink. It might be a friend that's bought you a drink that contained a higher alcohol concentration than the one that you asked for. It might be that you didn't realise that you were drinking a drink that contained alcohol. So again, you'd have to show that you took reasonable steps to try and work out what it was that you were drinking. You couldn't just drink without asking and then try and argue special reasons. And you may need some evidence of that as well. It does always help to get the person there that might have served you the drink. That's not saying they would get in trouble because they've not committed an offence. Get them there and to accept in court, or even just a witness statement that they gave you a drink and it contained alcohol. So special reasons, spiked drinks, is a really common argument that you see being raised in drink driving cases. Clearly it works better if the alcohol level in your case is lower. It's really difficult to argue if the alcohol level is high because it's less likely the court will believe that you consumed that amount of alcohol without actually knowing and then drove the car, because you're going to feel the effects of alcohol. Second argument that you see being raised a lot is short distance driven. Now, it's not the distance that you drove before you were stopped by the police, it's the intended distance. So if you only intended on driving a couple of yards, a couple of feet, a couple of metres, then that can be a really nice short distance driven argument. You'd have to have a good reason why you drove the vehicle and look at the criteria set out in the case of Chatters and Burke. There's about 7 questions the court will consider, and that's things like the condition of the vehicle, the manner of the driving, the reason why you drove the vehicle, and those are the factors the court can look at when considering whether or not you drove only a short distance. It's not just about the distance itself. Another special reasons argument that you'll see being raised is reflux, where the machine, the breath machine, has measured stomach gases as opposed to deep lung air. Now, of course, they're designed to measure deep lung air. That's how these machines work. That's the air that's closest to the capillaries, and that's how it actually measures blood alcohol concentration, but in your breath, and it's measured in micrograms. If the machine was measuring stomach gas as opposed to deep lung air, that can falsely elevate the alcohol content, and that can be a special reason. It is always very difficult to prove. You're going to need some expert evidence, and there are certain safeguards that are built into the evidential devices to try and stop that from happening. And a final special reasons argument that you see being raised is driving in an emergency. Now, this can in certain circumstances amount to a defence, what's called duress of circumstance. But if it doesn't amount to a defence, you could fall back on the special reason. And again, it's for you to demonstrate that the situation you found yourself in really was life, death, or serious injury, that you had no real choice, fight or flight, it was an emergency. It's partly objective, partly subjective, based on past experience as well. So it would have to be considered reasonably an emergency situation, but it may be that you considered it an emergency based on past experience. You'd also have to try and show that you did as much as you could not to drive. That was really the last resort. So did you call the emergency services? If not, why not? So the court are going to ask those kind of questions if you raise a driving in an emergency situation. But it can happen. You see these arguments being raised and sometimes they are successful. It's nice as a plan B. I always want to look at the evidence first of all. It may be that you've got a special reason actually that we haven't discussed in this video, and there isn't an exhaustive list of special reasons arguments that you can rely on. Different circumstances may amount to a special reason even if you don't know. So if you've got any questions, if you think you might have a special reason, please get in touch. Always happy to discuss special reasons arguments over the phone, and any of our initial advice is completely free of charge. You'll find our contact details in the description of the video and also on our website.